Welcome to Week 12's recorded lecture. This will be our last lecture on hearsay. We'll cover the readings from pages 454 to 467, and then 480 to 484 from your casebook. This is a short reading for this week, so we just have two cases. First case is Ohio v. Clark. This is a Supreme Court of the United States case from 2015. This case is dealing with the hearsay exceptions of statements describing child abuse or domestic violence. As background with this case, we have a 3-year-old LP who had told preschool workers that the defendant had hit him. LP, the child, was not allowed to testify at trial under state law because of his age. The state then introduced LP's statements at trial, and the defendant was convicted because of those statements. The defendant appealed, and the state Supreme Court reversed, holding that admitting the statements violated the Confrontation Clause. At issue here with the Supreme Court of the United States was whether these statements were properly admitted at trial, or did they violate the Confrontation Clause. The Supreme Court reversed unanimously. However, the court was split on the underlying reasons why LP statements could be admitted. Justice Alito wrote for the majority and discussed, again, that primary purpose test, which was created in Davis v. Washington. The court acknowledged that some statements made to non-law enforcement officers could create a Confrontation Clause issue, but said that those types of statements are much less likely to occur and much less likely to be testimonial than statements that were made to law enforcement officers. And in this case, again, the child made statements to their preschool teacher, not to law enforcement. And this court felt it was very relevant that the child was talking to his teacher rather than law enforcement in that decision of whether or not these statements were considered testimonial. And so in their view, they were not. Justice Alito also held that the child's statements were made during an ongoing emergency, so that primary purpose was to protect the child, not to gather evidence for prosecution. The next case was Stroud v. Cook. This is a United States District Court from the District of Nevada from 1995. This case is dealing with the hearsay exception of prior judgments. For background, the section of this case in your casebook is actually just defendant's motions in limine, and that was to exclude evidence of a prior conviction against him. So again, motions in limine are prior to trial, hearings with the judge and both parties to decide whether or not some pieces of evidence can be excluded at trial. So the defendant wants to exclude evidence of a prior conviction. The conviction in this case stemmed from a car accident where the defendant was convicted for failing to use due care and then fined $35. In this case, that conviction was criminal, and so it was potentially something that would be implicated under the hearsay exceptions. The plaintiff argues that the defendant's prior criminal convictions should establish that he is now, in this case, civilly liable for the plaintiff's injuries. At issue was whether the convictions that didn't satisfy the FRE 803-22, which is for prior convictions, can still be admitted under a different hearsay exception, like the public records exception. In this case, the defendant's conviction was not a felony, which is what is required under 803-22. So instead, the court considered whether the conviction could be qualified as a public record exception under 803-8. The court recognized that there was Ninth Circuit precedent that required that convictions be admissible under public record, though it did acknowledge that the different circuits were split on this issue. We didn't cover the case that dealt with the residual hearsay exception, but I'll touch on it briefly now. FRE 807 is a somewhat catch-all residual exception. And it states briefly that a hearsay statement can still be admitted, even if it's not admissible under FRE 803 or 804, which lists out all the other hearsay exceptions, if the statement is supported by guarantees of trustworthiness. And with that, the court also needs to consider the totality of the circumstances under which the evidence was made, and then if there is any corroborating evidence or statements, that evidence come in as well. And then the second piece to this is that it is more probative than any other evidence that the proponent could obtain through reasonable efforts. So this option is available, though it is a somewhat high standard to meet. So those were the only cases that we had for this week's reading. The end of your reading assignments was a evidence exam on page 480. We will go through these questions, questions 76 through 125 in class. Because there's so many, please do prepare these questions prior to class.